So let's start by looking at the relevance of this topic with respect to our examination. So for NABARD, this can be linked to the ASI portion under the subtopics Industrial and Labour Policy and Development of Banking and Financial Institutions in India. And with regard to RBI, this can be linked to the FM portion under the subtopics Recent Developments in Financial Sector and the Risk Management in Banking Sector. So let's start our discussion with the improvements that India has made in the Ease of Doing Business ranking, which is issued by the World Bank annually. So here India's rank has improved from 130 in 2017 to 100 in 2018. Now this Ease of Doing Business ranking is based on multiple indicators, and one of the indicators in which India has fared is resolving insolvency. So in this particular front, India's rank has improved from 136 to 103. So resolving insolvency is one of the key indicators for ease of doing business, and improvement in the rank on this front has been possible only because of the implementation of Insolvency and Bankruptcy Code 2016. So here the India's rank has improved in the World Bank's Doing Business Report 2018, which assesses over 190 economies across 10 indicators which cover the entire life cycle of a business. And one of the key indicators for measuring the ease of doing business, as we have just discussed, is resolving insolvency. So on this particular front, India's rank has again improved to 103. So the enactment of Insolvency and Bankruptcy Code has played a key role in this improvement, and further we can expect that many more changes can be made and are being made under the code. So this will further boost our ease of doing business rankings in the global scenario. Now before moving forward, it is essential that we first understand the meaning of some key terms. For example, insolvency, bankruptcy and liquidation. Now the terms insolvency and bankruptcy, they seem really similar, they seem synonymous, and we often use them interchangeably also. But we have to remember that there is an important distinction between the two, and we have to remember the technical difference between both of these terms. Now insolvency refers to a situation where any person or a body corporate is unable to fulfill its financial obligations. So if there is a person or if there is a company that has to pay some debt, but it is not able to honor that obligation. Now this may be because of several factors. It may be because of poor cash flow, it may be because of losses which it is occurring, and it can be because of other related issues. Now this situation will be referred to as insolvency. And bankruptcy, on the other hand, is a situation where a court of competent jurisdiction declares a person or entity insolvent. So bankruptcy is the next step of insolvency. Now when you become insolvent and a court of competent jurisdiction, a court of law, declares that okay, you are now not able to meet your financial obligation and you are officially insolvent, this will be termed as bankruptcy. So the court will pass the appropriate orders to resolve your situation and protect the rights of the people who have lent you money, that is the creditors. Now other important term is liquidation. So we have seen that insolvency is the inability of a person to pay their bills as and when they become due, and bankruptcy is when a person is declared by the court incapable of paying their bills, and liquidation is a step further. Now liquidation is the process of winding up of a corporation or incorporated entity. Now if it is found out that okay, this particular corporation is unable to pay its debt, so now the next thing which comes to picture is that either you have to restructure that debt or you have to wind up that company. So you wind up that company, you realize whatever you can from the sale of the assets of the company, and the proceeds from that sale are distributed to the different people, different creditors to whom the money is owed. So this process will be termed as liquidation. So if we look at the origin of Insolvency and Bankruptcy Code 2016, now this code was passed by the Parliament on 11th May 2016. It received the presidential assent on 28th May 2016, and it was notified in the official gazette on the same day. Now this code is a welcome overhaul of the existing framework. now there was some framework which existed prior to this particular code, and this framework we are going to discuss in detail in the coming slides. So this particular framework has been overhauled, this framework has been revamped, and now there is a completely new framework which deals with the insolvency of corporates, individuals, partnerships and other entities. Now this framework is nothing but the Insolvency and Bankruptcy Code 2016. Now the new law, that is this code, aims to consolidate the laws. Now we are going to discuss that earlier there were many laws, and now this code seeks to consolidate all those laws relating to insolvency and provide for the reorganization and resolution of a stressed business in a time-bound manner. So this is an important feature of this code, that there is a time-bound manner for resolution of the asset, and the focus will be on maximizing the value of the assets. So we are going to focus on maximizing the value which can be realized from the assets of a stressed entity. So now let's learn about why, who, when and how of the Insolvency and Bankruptcy Code 2016. Now why this Insolvency and Bankruptcy Code 2016? Quite simply, it was required to speed up the resolution of stressed assets in the country. So this you guys must have read almost every other day, that non-performing assets in the country are increasing, the stressed assets in the country is increasing, the ratio of stressed assets, NPAs to GDP is increasing. So there was a need to address those particular stressed assets. So to speed up the resolution of stressed assets, there was a need to bring in Insolvency and Bankruptcy Code. Now the who part. Now this Insolvency and Bankruptcy Code will be applicable to whom? So this code is a very broad code and will be applicable to individuals, partnerships, limited liability partnerships or LLPs and corporates. So the scope of this code is very wide, and it will be applicable not only to companies but other entity also. Now when? Now authorities which will be there under the code, it will be termed as adjudicating authority. We are going to discuss this in the coming slides. Now adjudicating authority is required to decide the insolvency application within 180 days, and a 90 days extension further may be allowed in some particular cases. So again the focus is on time bound resolution of the stressed assets. Also there is a provision for fast track of some cases. So in case of some small companies, there may be a fast track insolvency resolution process which will be implemented in 90 days. So again the focus is on time bound resolution on stressed assets. Now how? Now the most important authority under the Act is adjudicating authority, and this adjudicating authority is different for individuals and partnership firms and corporates. So these can be National Company Law Tribunal or Debt Recovery Tribunal. This again we are going to discuss in detail in the coming slides. So let's start by looking at some of the features of the Insolvency and Bankruptcy Code. Now one of the most important feature which we have just discussed in the previous slide also, that it provides a specific time frame under which the process of insolvency has to be resolved. So it provides a time frame of 180 days after the process is initiated, and a 90-day extension may be given for resolving insolvency. Now other important provision is that this code also contains provisions to address the cross-border insolvency. So this code is also going to be applicable on cross-border insolvency applications, and this will be effected through bilateral agreements with other countries. Now the workers' interests are also going to be protected under the law. So it has been taken care of that the workers who are the main people working in the company and who have spent their life working for the company, their dues are adequately paid off under the code. So for this purpose, their salary is up to 24 months, and the company's statutory obligation under the labor laws are given special protection. So this we are going to discuss when we will be discussing the priority, the order which is to be followed while liquidating a company and distributing the assets which have been sold and realized. Now this code further makes the provisions for a fast track insolvency resolution process, and this will be there for companies with smaller operations. So for them there is a provision that the process has to be completed within 90 days. Now let us look at some of the key aspects of the Insolvency and Bankruptcy Code. So one of the key aspects is that this code proposes a paradigm shift from the existing debtor in possession to a creditor in control regime. So this we are going to discuss in much more detail in the coming slides, that the creditor has been given much power for initiating the insolvency resolution process under this particular code. We are going to discuss that there are different categories of creditors and they are eligible to make an application to adjudicating authority for initiating the insolvency resolution process. The next point, it aims at consolidating all the existing insolvency related laws as well as amending the multiple legislations including the Companies Act. So this again we are going to discuss in much detail, that there were many laws, many insolvency related laws which were there in the country, and they were different for individuals and different for companies. Now they have all been consolidated into a single legislation in the form of Insolvency and Bankruptcy Code. So this is another important aspect of this code. So this code will be having an overriding effect on all other laws which are there to relating to insolvency and bankruptcy. Now this code aims to resolve insolvencies in a strict time-bound manner. This we have seen, that the insolvency resolution is to be completed within 180 days, and this period may further be extended by 90 days. So the total period can be 270 days in some cases. Now if during this moratorium period, that will the 180 days plus 90 days, insolvency professionals will be managing the company. So we are going to discuss in detail about the insolvency professionals in the coming slides. Next is, this code provides a clear order of priority or the waterfall mechanism. So under this particular code, there is a clear order, that is how the different assets which have been sold and the amount realized is to be distributed to different creditors or stakeholders to which the amount is due. So this order of priority is an important aspect, and this we are going to discuss in much details in the coming slides. Now the waterfall to render government dues junior to most others is significant. Now an important point here is that though there is an order of priority, and an important thing about this order of priority is that it prioritizes the workman's dues, and the workman's dues are ranked above the government dues. So this is an important feature of this code. Now also this code states that antecedent transactions can be investigated, and in case of any illegal diversion of assets, personal contribution can be ordered by court. So there may be a scenario where the directors or the related persons of a company may try to illegally diversify, to divert the assets of the company to some other use in order to prevent their sale for realization under the Insolvency and Bankruptcy Code. So there are adequate provisions to redress that. Also the code introduces a qualified insolvency professional. So there will be qualified professionals who will be acting as intermediaries to oversee the entire insolvency resolution process. And overall the entire process is going to be coordinated by the Insolvency and Bankruptcy Code of India. So this board will be established as an independent body for administration and governance of this particular code, and it will also be the overseeing the framework regarding information utilities, which are again important institutional pillar of this particular law. Now let us understand how the existing regime used to be there and now how we have moved towards the new regime in the form of this present Insolvency and Bankruptcy Code. Now earlier, the laws governing insolvency and bankruptcy in India were not consolidated. There were different laws which were governing the insolvency of the individuals. For example, the insolvency of individuals was dealt with under the Presidency Towns Insolvency Act 1909, which is popularly referred to as the Presidency Act, and the Provincial Insolvency Act 1920, popularly referred to as the Provincial Act. And for companies, again we had different number of legislations which included the Companies Act 2013, the Sikh Industrial Companies Act 1985 or SICA, or the Recovery of Debt Due to Banks and Financial Institutions Act 1993, and the SARFAESI Act, that is Securitization and Reconstruction of Financial Assets, and Enforcement of Security Interest Act 2002, which was there for companies. So clearly there used to be an overlap as several institutions had jurisdiction over the insolvency and bankruptcy process. For example, there was a company law board, there were high courts, there were debt recovery tribunals, and the board of industrial and financial reconstruction. So there was a need of harmonizing all the multitude of the legislations and the multitude of organizations which were there, and this harmonization has been done in the form of Insolvency and Bankruptcy Code. So the existing legislative framework comprised different kinds of laws which were there to regulate insolvency, and different kinds of mechanisms which were there to solve the insolvency proceedings. But now there is new framework in the form of Insolvency and Bankruptcy Code, and the provisions of this code are going to override the other existing laws on the matters pertaining to insolvency and bankruptcy. So the objective section of this particular act, now there is an objective section in every act, and for this particular act the objective section states that this is an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms and individuals in a time-bound manner for maximizing the value of assets of such persons, to promote entrepreneurship, availability of credit and balance the interests of all stakeholders, and to establish an Insolvency and Bankruptcy Code of Board of India. So this is the objective section of the Insolvency and Bankruptcy Code 2016. Now let us come to the most basic question under the Insolvency and Bankruptcy Code, that is, who can initiate the insolvency process under the code. Now to initiate the insolvency process, an application is to be filed to the adjudicating authority. Now this application can be filed by either financial creditor or the operational creditor or the corporate debtor. Now the financial creditor is the person to whom financial debt is owed. So they will be the persons who have loaned some money to the company. So they will be debenture holders, or they may be the banks who have given long-term loans to the company. And then there will be operational creditors. Now operational creditors are different from financial creditors in the sense that they are the people who are concerned with the day-to-day operations of the company. So for example, there is a person who has sold some goods to that company on credit, so he will become operational creditor. So they will be related to the operations of the day-to-day operations of the company. And then there will be the corporate debtor. Corporate debtor is nothing but the corporate person itself who owes a debt to any person. So these can initiate insolvency process under the Insolvency and Bankruptcy Code. So now let us briefly look at the process which is there for insolvency resolution under the Insolvency and Bankruptcy Code. Now the first step is that the creditors have to submit a plea for insolvency to the adjudicating authority. So first step is to submit a plea, and that plea has to be accepted or rejected within 14 days from the filing date. Now if this plea is rejected, the process ends then and there. But if the plea is accepted, then the insolvency resolution professional is to be appointed. The insolvency resolution person professional is assigned an important task, that is, it has to draft an insolvency resolution plan, and this plan has to be drafted in a time-bound manner, which we have already seen that this plan has to be drafted within 180 days, which can be extended by 90 days in exceptional cases. Now once this plan is drafted, the next step is acceptance of this plan by the creditors, by the people who have lent the money to the company. So this plan will be accepted by 75% of the creditors, then only it will be put into action. So if less than 75% of the creditors have accepted, this plan will end then and there. So if the plan is rejected, or if it is not passed by the adequate majority, then the company will be liquidated. So this is the brief process under the Insolvency and Bankruptcy Code 2016. So the first step is that the creditor or borrower has to approach the adjudicating authority, and once the case is admitted, insolvency professionals are appointed who are getting 180 days plus 90 days to draft a debt recast plan or the insolvency resolution plan. And if the 75% of the lenders agree to this plan, the restructuring will happen. Otherwise, the company's assets are going to be liquidated. So we have seen that the plea for insolvency has to be submitted to the adjudicating authority. Now, what is this adjudicating authority? Which authorities are going to act as the adjudicating authority under the Insolvency and Bankruptcy Code? Now, under the Insolvency and Bankruptcy Code 2016, now the power has been vested in the Debt Recovery Tribunal to act as the adjudicating authority in relation to insolvency matters for individuals and firms. So for individuals and firms, application is to be made for insolvency to the Debt Recovery Tribunal. All appeals from the Debt Recovery Tribunal are to be submitted before the Debt Recovery Appellate Tribunal. And the adjudicating authority in case of matters relating to companies and limited liability entities shall be the National Company Law Tribunal, and the appeals against the National Company Law Tribunal are to be submitted to the National Company Law Appellate Tribunal. And suppose if an appeal is to be made against the orders of Debt Recovery Appellate Tribunal and the National Company Law Appellate Tribunal, then this may be filed before the Supreme Court of India. So the code provides separate adjudicating authorities for individuals and firms and for companies and limited liability entities. So this we have to remember. Now there are two particular options which have been suggested under the code. So these particular options are restructuring or liquidation. So this we have seen. We are just trying to re-emphasize the importance of this concept, that if the resolution plan is approved, then the company will go for restructuring. The debt of the company is going to be restructured and some rejigging is to be made, and the company will be then again able to continue its business, though at a reduced size. Now this restructuring will be done if the firm is viable, and if the firm is not financially viable and the plans of the company are not approved, then the company will be going out of business, that is it will be undergoing liquidation. So now let us come to the next important topic, that is priority of payment of debts. So this we have discussed in some of the previous slides also, that there is going to be set order in which the proceeds which are realized from the sale of different assets of the company undergoing liquidation are to be given to different persons. How the amount realized from the sale of assets is going to be allocated. For this particular purpose, a priority order has been specified under the code. So let us look at this priority order. Now the first preference is given to the cost and expenses incurred by the bankruptcy trustee. So this is nothing but the cost and expenses related to the bankruptcy or insolvency process itself. So this is the first preference. And on second, there are workmen's dues for the period of 24 months preceding the bankruptcy commencement date. And on the third, there are debts owed to secured creditors, and the secured creditors rank equally with the workmen's dues. So second and third are ranked equally. That is, if the amount is less, it is to be proportionally distributed among the two. And next comes the wages and any unpaid dues to employees other than the one which is covered under the point number 2. And the fifth is any amount due to the central government and the state government, and all other debts and dues owed by the bankrupt, including unsecured debts, come at the last order. So the debts which are unsecured will be coming in the last preference. So first preference is accorded to the costs and expenses which are related to the bankruptcy itself, then come the workmen or the employees of the company, and then come the secured creditors, and then there is preference to the central government dues. So this is the priority of payment of debts. Now let us look at the 4 key institutional pillars which are there under the Insolvency and Bankruptcy Code. So these key pillars include the Insolvency and Bankruptcy Board of India, which is the regulator for overseeing the entities. Second is the insolvency professionals, which conduct the entire insolvency resolution process. Third is the insolvency professional agencies, which examine and certify the insolvency professionals. And the next is information utilities, which collect, collate and disseminate financial information related to debtors, that is, those people who have borrowed the money. So let us start with the Insolvency and Bankruptcy Board of India. Now the code provides for the constitution of a 10-member board in the form of the Insolvency and Bankruptcy Board of India. Now this board will be having representatives from RBI as well as the central government to regulate the insolvency procedures in India. This board will be acting on the general directions of the central government. So central government will be generally giving directions to this particular board, and this particular board will carry out different functions which include the registration and functioning of insolvency professional agencies, insolvency professionals, regulating information utilities, making regulations and bylaws and guidelines relating to different matters of bankruptcy and insolvency. Now the code also vests in this particular board the powers of a civil court. So this board is also assigned the powers of a civil court under the Code of Civil Procedure 1908 with respect to discovery and production of books and other related matters. So in some cases this board has also been assigned the powers of a civil court. So this is the present governing board of the Insolvency and Bankruptcy Board of India. So presently it is chaired by Dr. M.S. Sahu, and the other members are from different areas. For example, there is the Department of Economic Advisors, Ministry of Finance. It is represented by Dr. Shashank Saxena, and there is a representation from the Ministry of Corporate Affairs, Legal Affairs, and Reserve Bank of India. So this has very wide representation from different spheres of the different agencies which are there under the Government of India. Next, let us look at the insolvency professionals. Another code provides for the establishment of insolvency professional agencies. Now we have seen that the insolvency professional agencies are going to develop and regulate the insolvency professionals. Now the insolvency professionals are those people who are going to play a key role in managing the entire insolvency and resolution process. Now these insolvency professionals has to get themselves registered with the insolvency professional agencies and with the Insolvency and Bankruptcy Board. Now in this resolution process, the insolvency professional certifies, so the insolvency professional carries out a number of functions which include verifying the claims of the creditors, constituting a creditors committee. They will also be running the companies or the debtors business during the moratorium period of 180 days we have discussed, and they will also help the creditors in reaching a consensus for a revival plan. So we have seen that the plan has to be passed by the adequate majority for getting approved. So they will also be focusing on reaching a consensus towards a revival plan. Now if the plan is not approved, there will be liquidation, and in case of liquidation, the insolvency professional will act as a liquidator and bankruptcy trustee. So different kinds of functions are going to be performed by the insolvency professionals under this particular code. Now let us look at the information utilities. Now information utilities are going to be established under the code, and they will be required to perform functions relating to storing financial information in an accessible format, and they will also be publishing statistical information. Now an important thing which has been realized under the Insolvency and Bankruptcy Code is that it is vital that we collect different kinds of important information so as to monitor the levels of debt among the different companies in the country. So for this purpose, the code requires creditors to provide financial information to the information utilities. So information utilities will be provided with ongoing information by the creditors regarding the financial position of debtors, so that adequate monitoring can be done. So such information would be made available to creditors, resolution professionals, liquidators, and other stakeholders under the insolvency and bankruptcy proceedings. So information utilities are going to play a key role under the Insolvency and Bankruptcy Code. Next is penalties under the Insolvency and Bankruptcy Code. Now this code provides elaborate penalties, and in order to curb fraudulent and corrupt practices by any person, be it insolvency professional agencies or insolvency professionals or information utility, the code specifies elaborate penalties for them, and it further provides penalties for corporate entities that are not declaring assets or are fraudulently concealing their assets. Penalties will also be there for individuals who provide incorrect information, and the quantum of penalties will vary depending on the offenses which are committed by the individuals and officers of the company. Now that we have understood the different aspects of the Insolvency and Bankruptcy Code, now let us look at some of the expected benefits which are expected to arise due to implementation of this particular code. Now it is expected that this code is going to further increase the ease of doing business quotient of India. It will help India move from the countries with one of the relatively weak insolvency regimes to one of the world's best insolvency regimes. Now this is also expected to encourage innovation and entrepreneurship due to ease of doing business, and it is expected that it will make India a favorable destination for investment, thereby giving the boost to the FDI inflow. So more people will be interested to invest in India because they will be ensured that in case there is any mishap or the business is not able to sustain itself in the long run, there are adequate safeguards under the Insolvency and Bankruptcy Code for easier exit. Next is, it will also provide a solution to reduce the increasing NPAs which are plaguing the bank's balance sheets. So this is a critical issue, that there are many NPAs, non-performing assets, and we have to make sure that these non-performing assets are adequately realized under the Insolvency and Bankruptcy Code so as to revamp or reconfigure the balance sheets of the banks. This code is expected to ensure easy and hassle-free exit of sick companies, which will further improve the ease of doing business in the country, and it will enable a better flow of capital in the economy. So a lot of capital which is unlocked, which is now locked in the stress assets, is going to be unlocked. So this capital is going to be unlocked through the different mechanisms under the Insolvency and Bankruptcy Code. So guys, this was all about the basics of the Insolvency and Bankruptcy Code 2016. Thank you.